right? So to begin with due respect to my friend Vaibhav, I don't necessarily agree with him with respect to the competency of lawmakers in India. So as it stands today, we have privacy has three foundations. We have a strong common law privacy right, which has evolved over many years. Privacy has been recognized as a fundamental right under the Constitution of India. So the right to life in India has been deemed to include, or has been held to include, the right to privacy as well. And we have privacy provisions under various laws. The amendments under the criminal law in 2009, the amendments which have been brought about in the Information Technology Act, and the right to privacy bill, which should be passed this year. We've been debating this for the last 3 years. With that, we should have a pretty strong privacy law, right? So now, that sets the context for me, because right to publicity, which we'll be discussing now, has its foundation in the common law right of privacy. Without getting too much into its origin and background, I'll quickly take you through some basics of publicity, because I think we have not discussed much about publicity. Our focus has been primarily on privacy, so I thought I'll go through some basics before I get into what I want to say today. All right, now, the publicity right is the right to prevent commercial use of your persona without permission, right? In other words, publicity right is the right to control the use of your persona. Now, what do you mean by persona? Persona means or includes your name, likeness, your identity, your voice, your signature, and so on and so forth. Any element of your personality through which you can be identified is your persona. In India, who gets this right? Now, though under the proposed right to privacy bill, everybody has got the right to prevent use of his or her persona in one way or the other. Publicity right is primarily given to celebrities. Okay, now who is a celebrity? A celebrity is somebody who is recognized by the public. Somebody whom the public can instinctively relate to, somebody whom the public can immediately recognize as and when the public sees different elements of that person's persona is a celebrity, right? Now, when is this right violated? Publicity right is said to be violated if any element of a person's persona is used for commercial gain without authorization, right? So if a celebrity's persona is used by any person for purposes of commercial gain without taking the permission of the celebrity, then that person's publicity rights would be violated. There is an exception to publicity right violation, which is the right to freedom of speech and expression, right? So if the use of somebody's persona or use of a celebrity's persona is within the scope of your right to freedom of speech and expression, then you would not be liable for violating that person's right of publicity, right? Now, the law with respect to publicity has evolved very recently. It's only in a 2010 case that the specific elements of publicity have been really laid down in India. So I'll take you through this decision so that we can understand what the court said and how it enforced the rights of a specific celebrity. Now, this case deals with a Hindi pop singer called Daler Mehendi. Right? This person is a very popular guy in India. He holds the record for the most number of sales for a non-soundtrack audio CD, right? For a non-soundtrack audio work. Now in India, most of the audio CDs or music is based on films, right? We don't have non-film music so much as we have film music, right? So film music is very highly sold. Among the non-film music, Dalar Mehndi holds a record, and some of his songs have been recognized by BBC as the cult songs on the internet. He has more than, I guess now 29 million hits on few of his songs. And he also has given a license to this popular game World of Warcraft, which some of you might be aware. The victory dance that you see in the game is a typical dance move that he makes in his songs, one of his songs, right? So now let's have a look at how Dalar Mehndi moves. So this is Dalar Mehndi, and in fact, this is an album that actually sold more copies than any other album. Right now, what happened was there are a few gift shops which started selling some of his dolls. Right, these dolls not only looked like him, they also danced like him. And they also sang, his song, right? So, in response to that, Dalar Mehndi filed a case saying that his right to publicity is being violated. So let's have a look at one of these dolls.
Sorry.
So you've seen his doll. Does it look like him? So the court, looked at the arguments made by the counsel for Dalar Mehndi. Looked at and also heard the arguments made by the counsel for Dalar Mehndi. The other party, the gift shop owners, did not appear in the case, so this was an ex parte decision. The court held the gift shops liable for 3 reasons. First, the court said the gift shops were liable for violating the right of publicity of Dalar Mehndi. Because Dalar Mehndi is a very popular person, people can recognize him. The court said Dalar Mehndi is a celebrity. And because he is a celebrity, he has the right of publicity, which is the right to prevent unauthorized commercial use of his persona. And in this case, by selling these dolls, the gift shops were using his persona infused into the dolls in an unauthorized manner. And therefore, the shops are liable for publicity right violation. Pretty straightforward, and this case, in fact, laid down the principles for publicity rights. In a couple of other cases, the court indirectly referred to publicity right but never really ruled what publicity right actually is, and this case is very important for that reason. In addition to that, the court also held the gift shops liable for false endorsement. The court said by selling these dolls, which look like Daler Mehndi, the gift shops were misleading the public to believe that there is a business relationship between Daler Mehndi and these shops. That amounts to false endorsement, right? They're giving a false belief that Daler Mehndi has endorsed the creation of these dolls. By the way, these dolls were brought in from China. They're not made in India. Just like most things, they are made in China, right? So, false endorsement, the gift shops were held liable. Then, the gift shops were also held liable for passing off. For those of you who are aware of the tort of passing off, this is largely applied in trademark law. Passing off is a tort which is based in misrepresentation in the course of trade to consumers, which results in confusion, or which is likely to result in confusion among consumers with respect to the origin of goods or the goodwill associated thereto, right? So the court in this case said, because Daler Mehndi is a famous person, and a famous person in India has got the status of a level which is higher than that of a famous trademark. So the court brought in the trademark theory here. The court said a famous person has got or is on a much higher pedestal than a famous trademark, right? And therefore, in this case, by using this famous person's personality in a doll, they are liable for passing off. So they are passing off Daler Mehendi's personality in the doll, and therefore they are liable for passing off. Now, I am not necessarily comfortable or convenient with this analysis of the court. We'll discuss why at a later stage. Now, with respect to freedom of speech and expression, the court pointed out that freedom of speech and expression cannot be overridden by the right of publicity. In other words, though a celebrity has the right of publicity, a person will have the right to freely express, will have the right to freedom of speech and expression, and right to celebrity is limited by the right to freedom of speech and expression. Now, by virtue of the publicity rights having foundation in privacy laws, it's important for us to understand how courts will really look at what amounts to violation of right of publicity and what amounts to free speech and expression from the privacy point of view. Now, under the privacy law, we follow what is called as a proportionality test. It is similar to the balancing test that's followed in the US. The proportionality test says that in order to assess whether a person is liable for violating the right of privacy or the person's actions amount to free speech or expression, then you will have to balance between the impact on the person whose privacy is alleged to be violated versus the legitimate interest of the public with respect to free speech and expression, with respect to access when it comes to news and so on and so forth. Right? So you basically have to balance between both the rights and the impact a specific action can create on both the parties. Right? So proportionality test will, by virtue of publicity right law evolving from privacy rights, will most probably be applied to the publicity rights as well. So let us understand how this will come into play with respect to application of publicity rights on video games. Right, so now, because there are very few cases, and there is no case on video games or computer games in India till date, so I decided that we discuss about this with the help of a hypothetical. And then I picked baseball. I'm sure there are lots of Reds fans here, this room, so